All right, and to discuss this a bit more further, we are now joined by our legal expert or legal practitioner, Mpumelelo Zikalala, and he will be talking to us via our Zoom link. Mpumelelo, thank you so much for joining us here on the late edition. Let's start here. What do you make of the latest move by the public protector to approach the Constitutional Court over her legal fees?
I think it speaks of a public protector that says, I can no longer trust the protection of the law courts. I need to go to the court directly. I would love to participate in the process as much as I can. However, I cannot do so if I do not have the right tools in order to enable me to do so. Now, let's look at the balance of scales. When it comes to the committee, there's a full flesh or a full complement of representations or people that are going to assist it, that were presenting certain pieces of evidence or even cases on the last occasion when the public protector was not there. What are they doing? It cannot be said that they are purely advising the committee. They are the legal advisors of the committee, and they are helping the committee to understand or to navigate through the legalese or the legal terrain which is then available. Now, in order for you to balance the scale, you need to afford the public protector the same, and you cannot continue if the public protector is not represented. Now, part and parcel of that is, do you have an adequate amount of funds that will enable you to do so? As she perfectly stated in her submissions, do not only look at the fees which are going to be paid, look at administrative processes, look at other S&Ts, costs which are going to come in, like your traveling and accommodation. All of that has to be accounted on. And it cannot be that the lack of planning from the side of the committee must be, or the public protector must bear the brunt of it. So I think she speaks of a public protector that says, I'm really desperate to protect my rights, and I think the court is going to assist. And I'm really hoping that Section 167, which allows direct access, is going to allow me to go in. But there's another school of thought that would say the Concord then can then come back and say, this matter ought to have started with the provincial division, go back to the Western Cape provincial division, then the SAA up until you get to us. Do not jump all these courts because they all need to adjudicate your matter.
And it brings me to this question exactly. On what grounds here is she intervening and going directly to the Constitutional Court? Can a matter like this be heard directly at the Constitutional Court? Does she have grounds to actually take it to the highest court in the land?
If we look at our constitution, section 167, if I'm not mistaken, says, yes, you can have direct access. It is not something which is granted willy-nilly. It is done in exceptional circumstances where it is in the interest of justice that it is done so. So in this case, I think one of the first things that the public protector will have to deal with in the papers is explain to the court what is in the interest of justice, explain to the court the harm which is going to be suffered if they do not intervene at this stage. Why does it make it a little bit less practical if the matter were to start within the provincial division, then the SA before it gets to the Concord? Things that may be on her favor would be the fact that it's the first time in which we're engaging in this particular process. Secondly, we're not dealing with just any office that is there. We're dealing with the Office of the Public Protector. That needs to be done and dusted before her time is over in October. And that has certain ramifications when it comes to the work of Parliament and everyone who is involved. But on the opposing arguments, then one could then argue and say, you've followed the procedure all this time. There's nothing that necessitates or which is special about your matter. It has been adjudicated before. In fact, you've been given the funds. You may say that they're not enough. However, it would be much better if you come to us when you say, the 4 million which was granted to you has now been used up. Yes, you did sound a warning, which was good, perfect, but at the end of the day, utilize those because we are racing against time. You are wasting more time if you go to the court first, rather than when you are starting and listening to evidence and challenging all the other things and irregularities that you may have suffered when the time is right for you to do so.
And Mpumelelo, the issue of this 4 million rand, and she has raised it and says that it's not enough for this legal process. And you also raised the issues around, more costs are involved. There are costs of traveling. There are costs of SNTs. When she makes this, raises this problem of this 4 million rand, does she have grounds here when she raises it and says it's not enough for my legal processes?
Maybe a ground for a cause of concern in terms of saying, even if I proceed, you must know that I'm going to proceed now and the matter is going to stall again because this amount of money is going to be utilized or is going to be finished quickly. So it's up to you, Chairperson, what do you want to do? Do you want to continue with the risk of installation being evident, which I'm telling you now, which is going to happen based on the previous history? in terms of the expenses that you have engaged with my legal team? Or do you want us to hold back, go and seek more funds to allow the process and the flow of this matter not to be disturbed? It is not ideal to have someone who's going to go into the witness box, whether it's a public protector or anybody else, and then the delivery of the evidence is cut short or it is interrupted because there are no funds to pay the legal representation. Even if a new legal representation were to come in, the first thing that they're going to want to do, they would say, can we please study the Hansard or study the recordings? We want to put ourselves in the shoes of which the previous legal rep were in. We want to know exactly what is happening. And if it needs be, we may recall certain witnesses so that we're able to pose questions to them. So it's endless delays that can be there. So she does have a point somehow in terms of saying, look at the bigger picture. If I'm telling you now that you're going to experience a problem at a later stage, do you want to take the risk and not finish the job in which you've been given by Parliament? Or do you want to take a step back, go and get enough funding, and then allow the process to start and end or to conclude after all the evidence has been gathered so that you are able to evaluate it and come back to a reasonable conclusion, a reasonable recommendation in which you are going to recommend to Parliament?
And in Mpumelelo, we heard from the Public Protector's Office saying that initially there were no funds for her legal representation, and now this 4 million rand has been made available. What is the likelihood of her, winning this matter in terms of getting more funding to allow for a fair and legal process, especially in her regards?
I think our government has always worked. They say we are going to provide funding as and when it is needed. So we'd rather under budget than over budget. I think that's the way in which they've done. It's very rare where you'd find that our government is not going to spend funds in places where they need to spend funds. They always not provide adequately for a certain project that they need to provide for, especially when it comes to legal matters. One can simply look at the list of continuous liabilities of all departments and municipalities, and you come to the conclusion that they don't really plan for legal funding or legal services that they need at the end of the day. I think that's the same situation in which we are going to suffer now. There was no adequate planning, and one would want to ask, what informed the 4 million rands? What did you look at? Did you look at previous expenses that have been paid? Are there any disputes, or did you try and negotiate with the legal representatives of the public protector, able to try and reduce their fees? Let's look into all of this so that we're able to come to a reasonable conclusion. But while you are doing that, don't forget the legal bills in which you are paying for the legal representation, which are advised in Parliament, because it must be on par. So you can't say that for Parliament, I'm going to offer an X amount, which is exorbitant, and yet for the public protector, you want to negotiate, go lesser in terms of the funds in which you are going to be able to provide. That's not leveling the playing field. And in fact, what you are doing, you are saying to the public protector, go into this legal battlefield with less ammunition, and the chances of you winning are going to be slim. And this is not something in which a committee ought to have done. It's not something in which the committee ought to strive for. And I'm definitely sure that even Parliament does not want that. Parliament wants a report which is going to be honest, which is going to be independent and objective, and advise it accordingly as to what to do in a situation where there are these type of allegations against the public protector.
All right, then that is indeed Mpumelelo Zikalala, the legal analyst for us, giving us a bit of insight in terms of that legal impasse pertaining to the public protector's legal fees.